Hi, this is Kathleen Bonzik, and during the course of your career, you may be called in to give a deposition. What is a deposition? It's an out-of-court proceeding where one of the parties, the attorney for one of the parties, believe that you have relevant and material information to his or her case. During the course of the deposition, you may hear one of the attorneys ask a question of you, and then the other side will say, "Objection," and nothing further, or may say objection, asked and answered, or objection, hearsay, or objection, assumes facts not in evidence, or some other reason. What's going on? Is the attorney who's raising the objections trying to mess up the other party's flow or mess up the other party's deposition? No, that's not the case. A deposition is an out-of-court proceeding. Unlike court testimony, where you're going down to the courthouse and giving sworn testimony there's no judge that's present during a deposition typically. So the attorney who's raising the objection believes he or she has heard a defect in the question and raises an objection, usually to preserve the issue for later on, that it may be brought to the court's attention at some point down the line. You will still be instructed. You can go ahead and answer the question. You should answer the question if you have the information. Remember, you're under oath and have sworn to tell the truth, the whole truth, and nothing but the truth under penalty of perjury. In some cases, rarely, you will be told, do not respond to the question by the attorney who's raised the objection on the grounds of some type of privilege typically. It might be attorney-client privilege or some other reason. But more times than not, the attorneys will go about their business, they'll raise the one of the parties will raise the objection, and then they'll turn to you. At that point, you may forget what has been said, and it's a good idea, if that's the case, to ask the attorney to rephrase or restate the question, and he or she will be more than happy to do so. If you were in court, once the objection's raised, you've got the judge right there who can say, in response to hearsay objection or some other objection, either sustained, meaning the judge agrees there's a defect with the question and the attorney who's asked you the question must restate it or move on, or he or she will say overruled, and that means the judge feels that there's no problem with the question and you'll be instructed to respond. This is Kathleen Bonzik. Thank you for watching and for listening today.